Hello and welcome to Rules of the Game, where three lawyers demystify the rules nonprofits have to follow when they're advocating on the issues they care about. I'm Tim Mooney.
I'm Sarah Estemieux.
We're attorneys with Alliance for Justice's Boulder Advocacy Program.
Every day, we take calls and emails from nonprofits on how to safely and boldly take stances on women's health, climate change, civil rights, and much more.
On this show, we talk about some of the greatest hits, questions we get every day. We try to keep the jargon to a minimum, but if you're new to nonprofit advocacy, check out our starter video at boulderadvocacy.org/start.
Hello, everybody, and welcome to another special edition of Rules of the Game. Today, we are joined by a very special guest, a very smart and awesome one-of-us tax lawyer, one of us. Erin Bradrick is a principal at Neo Law Group, where she provides corporate governance, charitable trust, and tax counsel solely to nonprofits and exempt organizations. And this is where I get to call you out for being recognized as the 2018 Outstanding Nonprofit Lawyer - Young Attorney by the ABA Nonprofit Organization Committee, which I just think is awesome. I mean, that is a wonderful little feather in the hat. And in addition to all of the other accolades that you have, go check it out over at neolawgroup.com. Erin, thank you so much for joining us today.
Thanks so much for having me. Great to be here. And not sure I would qualify for the Young Attorney Awards anymore. So glad I got them in. I
mean, you did at one point. You're a young attorney forever, young attorney of note or whatever it was. So there you go.
Thanks, Tim.
So we talk a lot in this podcast about the rules. In fact, the name of the podcast is Rules of the Game. So we focus a lot on the difference between 501c3 and 501c4 organizations and how different rules apply. So how are the specific rules relating to election activity differ according to the tax-exempt status of a C3 versus a C4?
Great question. Yeah, so this is actually one of my favorite subjects to geek out on. So glad to be able to join you all for this important conversation. And I think it's an area where there's so much room for education in the nonprofit sector, right? So much room for empowerment in terms of really understanding these rules and understanding how an organization can act in this space to most effectively accomplish its mission, right? With all the tools that are available to it. I think understanding the distinction between 501c3 tax exemption and 501c4 tax exemption is an important part of that process, right? So for 501c3s, as a condition of their status as a 501c3 tax exempt organization, and it's in the language of the tax code itself, we have this rule that 501c3s can't engage in any intervention in a political campaign for elected office. Right? That means they can't support or oppose candidates for elected office at any level and in any manner. That prohibition is absolute, and the potential ramifications if a 501c3 does engage in prohibited electioneering or campaign intervention, I use those terms interchangeably, is potentially revocation of its exempt status, right? So it's a pretty serious limit. 501c4s, on the other hand, there's some trade-off. They're eligible to engage in partisan political activity, including supporting or opposing candidates for elected office, but it can't be the primary activity of a 501c4, right? So absolutely prohibited for C3s, permissible for C4s to some degree, and we don't have kind of a bright line of where that limit is for C4s. But the trade-off, of course, is that C4s don't generally get to receive deductible charitable contributions in the way that a 501c3 can, right? So there's some trade-offs that come with that freedom to engage in electioneering activity.
Interestingly, you had mentioned that one of the potential risks is the loss of tax exemption, which, absolutely, critical for 501c3s to maintain, as well as any other tax-exempt organization. I'm curious what you've seen in your experience. Are there other external agencies or groups that organizations should be thinking about, not in addition to the IRS?
Possibly. We're not seeing a whole lot of enforcement around this issue right now at the IRS level. Partially, I think, because of underfunding and understaffing within the IRS exempt orgs division, potentially. But also, it's a really politically charged issue, right? And to kind of demonstrate the absence of enforcement, we have organizations that intentionally violate this prohibition on 501c3s every year, including religious organizations that encourage pastors or religious leaders to intentionally violate this rule from the pulpit with the goal of getting the IRS to revoke the tax-exempt status of a church or religious institution so that the prohibition on C3s engaging in electioneering can be challenged in the court. We also right now have a pending lawsuit related to this prohibition, right? We have a charity that intentionally was formed to challenge this prohibition, that checked on its exemption application that it was planning to engage in prohibited campaign intervention as a C3. The IRS didn't rule on its exemption application, and there's a statute that allows an organization that doesn't get a ruling on an exemption application in a certain amount of time to then challenge it in court, right? So we do have all of this stuff kind of going on around this prohibition at the federal level. But then there's also a question of state income tax exemption, right? So most state income tax exemption rules that I'm familiar with are tied kind of to the framework for federal tax exemption, right? So including in California where I am, which means that if an organization engages in prohibited campaign intervention activity, it may also be ineligible for state tax exemption at the state level. And potentially we could see state charities regulators also take issue with the use of charitable asset for these types of activities, right? So in California, that's the attorney general that's charged with overseeing the proper use of charitable assets in the state. So for example, we could see action by a state AG or an equivalent body around misuse of charitable funds.
You had mentioned about the primary activity of a 501c4, and that's of course going to be essentially the same kind of stuff that a 501c3 can do, and tax law demands that. So we'll often see nonpartisan election-related activities by both C3s because they have to stay in that area, and by C4s because there's a benefit to them to build up their primary purpose activity by doing that kind of nonpartisan work. So what does it look like? What are some of the types of nonpartisan election-related activities that you tend to see? And are you seeing some of them rising in importance more recently and some falling in importance based on political factors and things like that? I'm just curious what you're seeing.
So this is, I think, one of the biggest areas where there's room for empowering education, right? I think even though a 501c3 cannot engage in partisan political activity, campaign intervention, it can engage in a lot of stuff related to election, right? And the key there is that it's got to be nonpartisan in nature. So the idea is that the organization is engaging in activities that aren't intended to influence the outcome of an election, but have some other broader purpose. And that purpose can be a bunch of different things, right? It can be issue advocacy. It can be encouraging voter participation, or perhaps commenting on sitting elected officials in their official capacity. It can be voter education or candidate education even, right? And the key with all of these activities is that they're engaged in a nonpartisan manner. So we do see C3s really stepping up those nonpartisan election-related activities during, obviously, election years at the federal level. We also, like you mentioned, Tim, see C4s that are really building up those nonpartisan election-related activities because they need something other than campaign intervention activities to be the primary activity of the organization. It's also worth noting that if you take a look at all of the C4s that are out there, actually a vast majority of them do little to no campaign intervention activity, right? So there are also a bunch of C4s that are out there doing social welfare activities that have nothing to do with campaign intervention, even though it's permitted for C4s. So it's, I think, helpful to make sure we're balancing the common narrative that C4s are just political vehicles. But in terms of what I'm seeing in terms of permissible nonpartisan election-related activities, I think we see a whole lot of voter participation-related activities, right? So voter registration campaign conducted in a nonpartisan manner. We see a lot of get out the vote activities in terms of actually facilitating voting by all who are eligible to participate in our democratic process. We certainly see a lot of issue advocacy, including leading up to election, that has to be navigated very carefully. In my case, a lot of the clients I work with are very much issue advocacy organizations, and many of them on the more progressive side of the spectrum. And where they need to be a little bit careful is as they continue the issue advocacy that they have long engaged in, but we get closer to election time, being very, very careful that those issue advocacy communications don't cross the line into campaign intervention. They don't start to look like you're inviting voters to compare the positions of the organization with the positions of candidates. That if they are wedge issues that candidates are talking about, that they're being really careful in terms of how they frame their positioning, not tying it to the election, not tying it to particular candidate, right? A lot of my issue advocacy organizations also will try to hold sitting elected officials accountable for actions taken in their official capacity. Both activities that are absolutely permissible for 501c3 public charities if they're engaged in a nonpartisan manner, but it all gets much more complicated when you're doing both of those things and you're getting close in time to an election, particularly where we have incumbents running for re-election, right? So a lot of the work that I do is really helping organizations think through how we frame things, the timing of communication, the positioning of communications, how it looks from a broader optics perspective in terms of what the organization is really trying to accomplish with the activity or the communication and tying it to something other than trying to influence the outcome of an election.
I think that's really well said. The tacit endorsement angle, of course, is the biggest thing that we run into, I think, when we get questions on people around issue advocacy. It just seems to be the thing that people have a hard time wrapping their heads around. I'm looking at a poster for the very first nonpartisan voter engagement thing that I did early on in my career. And it was for a voter guide. And way back in the day, back when Gen X was not graying and we were cool, and we were young voters at one point too. We ran this young voter guide in Portland, Oregon, and we put out the questionnaires as the IRS demands of these things, and we got responses from all the different parties. And I feel like that's not happening so much anymore. Do you see that too? And, these rules that were written in the 1970s and 1980s when the politics of things were very different make it more difficult to usefully utilize these safe harbors. What do you think about that?
I fully agree, right? We're not seeing a lot of organizations do voter guides, candidate questionnaire type work, at least not in the C3 space. I am seeing C4s do voter guides that are partisan in nature, right? So as essentially a campaign intervention activity, they then need to make sure it's not their primary activity. So we are still seeing that kind of as a thriving activity in that space. But on the C3 side, I'm not seeing a whole lot of C3s that are trying to put out nonpartisan voter guides or candidate questionnaires in compliance with the guidelines that we do have from the IRS around those. I think part of it is that in our highly politicized current environment, I think organizations that are issue advocacy organizations on both sides of the aisle, the spectrum of issues, I think have become so closely affiliated with political parties and political viewpoints in the general mind, right? And in kind of the general societal perspective, even if they have not actually engaged in anything impermissible for a C3, right? But because the issues are so politicized, I think it's gotten to a point where I think if an organization put out, a candidate questionnaire, I think they could safely assume they would not get responses from half of the candidates on the other side of the issues, right? And I think that makes it really hard to actually put out a nonpartisan voter guide that involves, candidate responses and still kind of fits within the guideline of what the IRS has shared.
Now, Erin, when we're talking about issue advocacy, that also raises another point that we've seen a lot more questions and interest in on our TA line and from the workshops we get through Boulder Advocacy too. And that is that as people are getting more involved in particular issues, there are smaller groups, okay, what can we do? We want to do something, but we're right in an election season. We don't have time to form a 501c3 or a 501c4 because, as this can take years and years to get through and get the exemption. So fiscal sponsorship may be a very good option for these smaller groups. If they decide to go under fiscal sponsorship, whether it's under a C3 or a C4, depending what they want to do, what are some of the activities they could engage in as a fiscally sponsored project around election season activities?
Yeah. So fiscal sponsorship is my other favorite subject to geek out on. So we're covering all my favorites in this conversation. I think it's important to note too that you can actually, as a 501c4, self-declare as tax exempt with the IRS, right? You do need to file a form notifying the IRS of your organization's intent to operate as a 501c4. We don't necessarily have to file that exemption application and wait to hear back. So it is possible for, an organization that plans to engage in social welfare related activities to actually get a C4 up and running really quickly. And so that's one potential option if it's not an entity that's seeking C3, or if it's an organization that wants to engage in some of the things that a C3 can, right? But if you have an organization that actually is seeking to engage in C3 consistent activities and wants access to those charitable dollars, right, whether it's private foundation grants or it's individual donations for which donors want to be able to take charitable contribution deduction, then fiscal sponsorship can be a great option. I think it's important to note that the term fiscal sponsorship doesn't actually tell you a whole lot about what relationship is in place, what structure is in place, right? So fiscal sponsorship is kind of an umbrella term that refers to a bunch of different contractual relationships that can be set up that essentially allow, in most cases, a C3 to support activities that are being run or were kind of the brainchild of an entity or an individual that's not itself a 501c3. Right? But then it can take on a whole bunch of different forms. The most common form, and I think the one that's probably most relevant to your question, is called comprehensive fiscal sponsorship, or it's sometimes referred to as Model A fiscal sponsorship, coined by Greg Colvin many years ago. And in Model A fiscal sponsorship, if you have an idea for a project, right, you're a small group and you want to get it up and running and it's 501c3 consistent, you can essentially go to an existing organization that is a 501c3 and say, what I want to do is aligned with what you're already doing, aligned with your mission. Here's how I want to do it. And if you enter into a fiscal sponsorship relationship, the project essentially becomes an internal program of that 501c3 fiscal sponsor organization. That means from a legal perspective, everything that project does is the fiscal sponsor doing it, right? So when we talk about these campaign intervention rules, that means that as a fiscally sponsored Model A project, you're inside of the 501c3. You can't do anything that the 501c3 can't do it, right? And that means all of the prohibition on electioneering campaign intervention activities also applies to a Model A project. So it doesn't get you anything that you wouldn't otherwise get if you formed your own 501c3. But it does mean you can get the project activities kind of up and running much more quickly than if you were going to wait until you got a determination letter for a newly formed entity as a C3. The other thing I'll just note is that I think a lot of 501c3s are pretty well aware of this campaign intervention rule, right? And short of the ones who are intentionally violating it to try to prod the IRS into a revocation, we don't actually see a lot of kind of missteps in this space where a 501c3 very obviously has engaged in campaign intervention. But I think where there's some of the greatest risk is actually within Model A fiscal sponsor organization. And I think it's because Model A fiscal sponsorship, when you have an organization that is fiscally sponsoring a large number of projects, it is kind of inherently more decentralized. Right? It ends up kind of operating on a day-to-day basis, almost as a bunch of kind of little nonprofits within a larger nonprofit. And what that means is that if the fiscal sponsor hasn't done a really great job of educating all of the project directors, all of the staff working on the individual project, even down to volunteers in some instances around the nuances of these rules, particularly around permissible nonpartisan election-related activities, the risk, I think, of an organization inadvertently crossing the line into campaign intervention starts to go up, right? So, for example, where we've seen it, a Model A fiscally sponsored project that had a very small set of programmatic activities within the project and sent out a newsletter to its members. And they had a former member running for mayor. And so they put in a nice statement about the former mayor or former member who's running for mayor, what a great person this individual was, and how everybody should go out and support them. But because it's a Model A project, the newsletter was an activity of the 501c3 fiscal sponsor, and the support for a former member who's now running for mayor was campaign intervention, right? So I think within fiscal sponsors, the need for education is maybe even greater than within kind of other non-fiscal sponsor 501c3s that might have more of a centralized oversight model for all of their programmatic activity.
That's interesting. And I can see where that could make some fiscal sponsors very risk adverse and almost not give permission to the projects to do all that they can do legally. So for a group that, again, they're just thinking about, they're thinking about the election season activities they want to do, they want to get going. What should they look for in approaching a sponsor? Do they need to focus on an existing sponsor that's in their geographical area? Are they limited by their state? What kinds of things could they be asking and thinking about?
Yeah. So for the side of these laws that I advise on, so the tax exemption law side of things, it's not necessarily the case that you need to look only for a fiscal sponsor in the state where you're located, right? Because we're dealing with federal tax law. So there could be state law implications under kind of state election political laws that are worth considering. But on kind of my side of the coin that I work on, that's not going to be so relevant, right? I think really fundamentally what it comes down to is less legal concerns and more relational concerns, right? It's about finding a fiscal sponsor where there's the right fit, where there's trust, where there is appropriate capacity within the fiscal sponsor, where there's a deep understanding within the fiscal sponsor staff of what is permissible and what isn't, where there's educational resources available. Someone on the staff you can go to and ask questions to help direct programmatic activity, right? So it's more kind of operational and relational than legal in nature, since the legal issues and considerations will be the same for all 501c3 public charities from a tax exemption law perspective. And the question then is how they approach those rules and how they approach the activities of fiscally sponsored projects while maintaining compliance. I hope though, Sarah, that, maybe I'm overly optimistic, but my hope is that in talking about these rules, that it's actually inspiring for 501c3 public charities to learn more and to understand how really getting these rules, really knowing them, knowing what the parameters are, knowing where the lines are, knowing what guidance we do have, what we don't have, is actually helpful in kind of realizing all these tools that are available to 501c3s to engage in mission-oriented, impactful work, right, in furtherance of the great work they're already doing. So hopefully it's not overly intimidating and leading to risk aversion unnecessarily, but I hear you.
So Erin, Sarah and I were in Las Vegas at the Ballot Initiative Strategy Center conference a few weeks ago. And of course, listeners to the pod heard all about that. And, what really struck me was how much advocacy is being done at the ballot on issues. And I'll highlight one issue, abortion rights. And, we've got an enormously important election that's coming up here. Many 501c3s are going to be working to protect abortion rights at the ballot. And it occurs to me that there's an interesting boomerang effect that happens. If you're driving get out the vote on an issue as contentious and as politically hot as abortion, and because it cleaves so closely along partisan lines, inevitably, as a C3 public charity that is legally getting out the vote, to vote in a particular way to protect abortion rights at the ballot in a ballot measure context, that those same voters are probably going to vote in a partisan way around candidates. That's something that the C3s obviously can't engage in. How do you avoid problematic situations like that from your perspective? How can you stay on the legal side, be advocating on the ballot measure, doing your GOTV work, and avoid crossing that Rubicon into the impermissible space regarding the candidates?
Very carefully, right?
There you go.
I think, it raises a number of issues, right? One being that we've been talking mostly about the 501c3 prohibition on campaign intervention, and we haven't necessarily talked about other forms of advocacy, including legislative lobbying, right? So unlike the absolute prohibition on campaign intervention, of course, 501c3 public charities can engage in an insubstantial amount of lobbying activity. And that includes lobbying related to ballot measures, right? So any kind of matter put on the ballot but for a vote by the people that's more legislative in nature is generally going to be subject to the federal rules around lobbying activities for 501c3s, right? But it also then ties into if an organization is engaging in multiple nonpartisan election-related activity. So issue advocacy, legislative lobbying, and perhaps also get out the vote activities I heard you mention, right? Each of those things, fully permissible for a 501c3 public charity if done properly and subject to limitations on how much lobbying the organization can do, right? Where it gets a little bit sticky and what you were alluding to is when you start combining nonpartisan election-related activities, they suddenly can actually cross the line into campaign intervention. So just giving the example you were doing, Tim, I think, could a C3 public charity engage in nonpartisan get out the vote activities and voter registration activities? Absolutely. Could it separately also engage in issue advocacy around a wedge issue that has been a hot button in an upcoming election? Yes, right? If done carefully. But if you combine the two, so if you go to register voters and at the same time you say, thanks so much for registering, now make sure you go and vote. Abortion's on the ballot, and it's really important that we get this right in this upcoming election. You've now combined the two in a way that probably crosses the line and starts to look like campaign intervention. Like you're actually trying to not just encourage people who are eligible to vote, participate in our democratic process, but to get them to vote a certain way. And that crosses the line. Similarly, you can engage in legislative lobbying activities around a ballot measure, and that ballot measure may be on the same ballot where you have political campaigns for candidates occurring, right? But if you start to cross the line and blur your legislative lobbying around a ballot measure with your get out the vote or voter registration activities or with comments about the election more broadly, you run the risk of crossing that line into prohibited campaign intervention, right? So I think when we're working with clients in this space, it's really about, number one, internal education and for all of your comms staff, for anybody who's controlling your website, your social media content, for anybody who's out making public statements verbally on behalf of the organization, right? It's really about training and education and for everybody really to understand ahead of time where those separations need to occur, where things need to be kept in a particular lane in order to best protect the organization in this space. But it can be done, right?
And it was interesting, your example of abortion rights are on the ballot. In some instances, they literally are. And saying that in those contexts, perfectly fine for a C3 to say. If you're in a state where that is not the case, very problematic. So that's really,
you're
really
referring to candidate. Yeah, exactly.
So I'm curious, is there anything else that you think would be really important for a listener with a C3 in particular, but any tax-exempt organization? If there's one takeaway that they would have from your time here on the pod that we haven't talked about, what would you communicate to them?
I guess my main point whenever I have the opportunity to talk about these topics is really just encouraging people to dive deeper into these rules. I think they can sound complex and somewhat intimidating. And my hope would be that the takeaway would be that it's worth it, right? It's worth investing in really understanding where these lines are, where the considerations are, and all that can be done by tax-exempt organizations to really impact their missions within the confines of tax exemption law, right? Because there is a lot. So my hope, I guess, would be that they would turn to your resources. They would really kind of dive deeper and invest more in really deeply understanding these rules so that they can think big about what tools are available to impact their missions positively.
Erin Bradrick from the Neo Law Group, a frequent author of the nonprofit law blog and now a professional podcaster. Thank you so much for joining us on the show.
Thanks so much for having me.